Hi, everybody. Thanks for tuning in. Before we get started, I wanted to just take a moment to acknowledge the incredible losses that are being suffered by so many, by individuals, by our country as a whole, and also throughout the world, and say that my wish is that we all find some peace soon. That being said, as you all know, today's seminar, we're going to be speaking about the homestead and ways to best protect the homestead when it comes to the Medicaid application process, Medicaid eligibility. So as Liz said, and I don't know if it was me or on Liz's side, but you certainly can ask questions throughout the webinar. As I see them pop up, I'll be answering them. I'm going to try to first explain how the homestead, the primary residence, is treated in the different Medicaid programs in the state of New York, and then talk about the best way to protect the home. So I'm calling it the homestead because really what we're talking about generally is your primary residence. So when we talk about the homestead, we're talking about an individual home that you live in. We could be talking about a condominium and also a co-op. So any sort of residence that is your primary residence and is your home. And I'll talk a little bit at the end, if we have a moment, about protecting secondary property. What I'll tell you is that in New York Medicaid, there is no protection for second homes. So really, when we're talking about asset protection in the Medicaid program, we're talking about your primary residence. So as a general rule, if we're talking about community-based Medicaid, so this is the Medicaid program where you're going to be receiving care at home. Your house is an exempt asset. And what that means is that you can, despite the fact that you might own a home, you can apply for community-based Medicaid. There is an asset limit, and I'm sorry, a value limit on the house, and the house cannot be worth more than $878,000. To the extent that the equity in your home exceeds $878,000, excuse me one quick second.
If anyone has any questions, please feel free. Like I mentioned on the bottom of the screen, there is a Q&A. You can type those in there.
My apologies. Okay, so to the extent that the equity in your home exceeds $878,000, there might be some additional planning that we need to do. However, let's assume that you own a home, that the equity in the home does not exceed $878,000, and you apply for community-based Medicaid. The house is exempt during your lifetime. And what that means is that without consideration of your ownership of the home, you can apply for Medicaid, you can receive Medicaid benefits, and your ownership in that house will not affect your receipt of those benefits. That being said, it is incredibly important when doing Medicaid planning for community-based Medicaid that you take into consideration that home, even though it's exempt, because although it's exempt during your lifetime, it is not free from Medicaid recovery. And what that means is that if you've received Medicaid benefits during your lifetime, you then pass away, Medicaid can come in and ask for payback from the sale of the home. So although it is exempted during your lifetime, it is not free from estate recovery if it passes through your probate estate. However, if you do the Medicaid planning and you make sure that the house does not pass through your probate estate, and rather provide that the house passes through some sort of a testamentary substitute, perhaps a trust, there will be no estate recovery. So that's one very important point about the homestead. Liz, I'll take those questions. Okay. Thank you about the comment about my dog. And the next was, how do I evaluate a home with a reverse mortgage? Well, that's a great question. If a home has a reverse mortgage on it, what you're going to want to look at is whether there is any equity in the home. So a home could have a reverse mortgage and there could be no equity in the home, or you could have a home with a reverse mortgage and there could be a substantial amount of equity in the home. So what we're going to want to look at is what is the amount of the reverse mortgage and how much equity do you have in the home, and is it worth doing any planning? And there are special considerations when dealing with reverse mortgages because some of the planning is limited depending on the provider of the reverse mortgage company. So it could get a little bit tricky. Okay, so community-based Medicaid and homes, that's the general rule. Chronic Medicaid, so that's Medicaid that deals with a nursing home, so Medicaid that will pay for your stay in a nursing home, a little bit of a different analysis. So when we talk about Medicaid and a nursing home, the home is not exempt unless there is a spouse living in it, there is a minor or disabled child living in the home, or unless you can show that you have a subjective intent to return to the home. So what does that mean? Well, the first three examples are pretty straightforward. If you own a home and you are married and that spouse either owns the home jointly with you or lives in the home, the house is exempt and Medicaid cannot count it against your eligibility, nor can Medicaid place a lien on the home. If you have a minor child living in the house is exempt and Medicaid cannot place a lien. If you have a disabled child living in the home, same thing. However, let's say that you have none of those circumstances and you require care in a nursing facility and you want to go into the nursing home, but you still own this home. And there's a chance that you might return home, and you have made it known that it is your wish and your intent to return home. If you meet all of the other eligibility requirements for Medicaid, and you can show a subjective intent to return home, and that is an intent to return home despite any medical diagnosis you might have, and that's a change in the law, not a recent change in the law, but a change in the law that took place back in 2003. Then the house is exempt. However, the social service department will place a lien on the home. If in fact you end up going back home, the lien will be removed. If you die in the nursing facility, the lien will be collected upon. And if you end up selling the home, the subjective intent to return home obviously then goes away and you will have to do additional Medicaid planning. There were a few cases about this in the last few years about this intent to return home issue, and one of the big questions was, if you have applied for chronic Medicaid and you have indicated that you have an intent to return home, but that intent to return home changed at some point, and you listed your home for sale, at what point can Medicaid count that home as a resource and deny you Medicaid coverage? And the law at this point is pretty clear that at the time that the contract of sale is signed, the house will no longer be deemed exempt. You will lose Medicaid benefits and you'll have to pay for the nursing home from the proceeds from the sale of the home. So in New York State, it's important to be mindful of planning when you're dealing with the potential for nursing home or home care in the future, because for most of us, our home is our most valuable asset. And what is the best way to protect the home? The best way to protect the home is to do planning well in advance of you needing care and transferring that home into an irrevocable trust. An irrevocable trust is a trust that will protect the home, whether you need home care Medicaid or whether you need chronic Medicaid. You can still remain in the home. You can maintain any tax benefits that you have by way of owning the home. You can sell the home, which is a question that a lot of people have. They say, okay, well, if I put my house into an irrevocable trust because I'm trying to protect it for Medicaid down the line and I decide I want to move, what are my options then? Well, you can certainly sell the home. You can buy replacement property. You can invest the money in another property. You can invest the money in the stock market, and you can use other money for your living expenses. So there are a lot of ways and a lot of flexibility when it comes to estate planning and the best way to deal with the home. A lot of my clients, when they come to me and we're talking about planning, particularly for community Medicaid, say, well, if the house is exempt, why would I bother putting it into the trust? And I'll go back to what I said in the beginning, which is, one, if we're already doing planning for community-based Medicaid, then there's a good chance that we might be needing to do some planning for chronic-based Medicaid down the line. And we want to get that 5 years ticking on the trust. The second reason that we might want to make sure that we get that planning done is because of the estate recovery that I explained before. Now, if you've been following our webinars or following the news with respect to issues surrounding elder law and Medicaid planning, what you might know is that in October, we are expecting a significant change in the law that will create a 2.5-year look back for community-based Medicaid. So now up until October, there is no look back for community Medicaid, which means that you can apply for Medicaid today as long as you're eligible, and they're not going to look back at any transfers that you made. So one of the questions, and we don't have the answer yet, that we're looking at is, well, what about the home? And if we transfer the home during that 2.5-year look back, is there going to be an issue? Now, the house is an exempt asset, so our expectation is that there will not be an issue, but this is something that we'll be following up on and that we'll be reporting to you as we learn and as the law changes. Okay, so question. My sister and I are on, I'll do it.
You got it.
My sister and I are on the deed of a house. I am on Medicaid and my sister is not. She is worried about making me executor on her will since she is afraid of the potential consequences of me being on Medicaid. If my sister passes away and I am now the sole owner of the house where I currently live, would Medicaid come after me for money? The house is not worth $800,000. Well, that's a great question. So the first thing that I'll say to you is that if you and your sister are on the deed of the home and you own it as joint tenants with right of survivorship, the will's not going to come into play. It's going to pass to you by operation of law without you needing to be the executor or not needing to be the executor. I would then follow that up, trying to answer each piece of your question by saying whether or not you are the executor on the will is not the issue. Depending on what type of Medicaid you're receiving, and you've not given me that information in the question, if you're receiving Medicaid health insurance or community-based Medicaid, then the house is exempt. If you end up in a nursing home needing long-term care, then you're going to have to do some planning on the house. So what I would say is that I don't think you need to be concerned if it's Medicaid health insurance that you have. However, if you're on Medicaid because you have some underlying medical issues, it might make sense for you and your sister together to do some planning with the house so that the house stays protected and ends up going to whoever your intended beneficiaries are. So next question. What if you are divorced, have a reverse mortgage for what if you are divorced, have a reverse mortgage for a number of years, and the reverse mortgage is much higher than the house value? Example, house is valued at $300 and the reverse mortgage is now $375. I would say that you have a debt on the home that exceeds the equity in the home. So there's probably not a need to do any planning. You certainly don't need to protect negative equity. If you were to, God forbid, go into a nursing home, my guess is that after a short amount of time, the reverse mortgage company would come and they would foreclose on the mortgage and take the house back. So at the point where you have negative equity in a home, we're not so worried about protecting it, obviously. And for as long as you're living in the home, the house is protected. So you don't need to worry about that. Okay. Another thing that we wanted to touch on a little bit, because of course we're doing these webinars and we have offices that are in Long Island as well as New York City, is that when we talk about the trust and the asset protection and the protection of the house, we're also talking about co-ops. And a lot of people come to us under the impression that you can't transfer a co-op into an irrevocable trust. And what I'll tell you is that as of recently, we've had quite a bit of success in transferring co-ops into irrevocable trusts. So you definitely, when considering your planning, want to make sure that you are looking at your co-ops as well. I also said that I would speak a little bit about second homes. So when we talk about the homestead, we're talking about your primary residence, also protected, or any other structures on the land of that primary residence, and any property that's considered by the town to be contiguous. But let's say that you own a home and you have a second home in Florida and you snowbird. That second home in Florida has no exemption if you're looking for New York Medicaid. So you need to make sure that you get the asset protection planning done well in advance of needing any sort of care. And again, being mindful that we're going to be instituting a look back for community-based Medicaid this coming October. You definitely want to look at what your assets are and start doing some planning. What are the Medicaid limits on disposable assets? I'm not sure if this is the question, so I might ask you to just clarify if I don't answer properly. But the Medicaid limits, if you are applying for Medicaid, you can have liquid non-retirement assets in your name of $15,750. You can have retirement assets of an unlimited amount so long as you're taking a distribution. If you are in a nursing home, you are entitled to only $50 per month in income. And if you are living in the community, you can keep $895 worth of income, and all of the income that is above that goes into a pooled income trust. So the asset and income limits for Medicaid qualification are quite low, which is why the advanced planning becomes quite important, because we want to make sure that we get the assets protected well in advance of you needing any care. Again, the last thing that we want to see is that you have worked your whole life to pay off your home, and now, God forbid, you need a nursing home, and we have to fire sale the house to get the equity out of it to try to preserve some of the assets. And the planning can be done, honestly, quite cost effectively and quite simply through the use of a trust. That usually raises the question of, well, if the only asset that I have is my house, and I have a really good relationship with my kids, why don't I just put the house in my kids' name? And I will tell you that I recommend that you don't do that. And the reason that I recommend that you don't do that is that if you take your home and you transfer it out of your name and put it into your children's name, one, you're potentially going to lose any of the tax benefits that you have by way of owning the house. Two, you then subject your home to any of your children's creditor issues. And so what does that mean? That means that if your child ends up getting divorced, the home is now in their name and is potentially subject to their equitable distribution. If, God forbid, they get into a car accident, the house is going to be subject to their creditors. It is much safer and much better to do the estate planning. Finally, and I hope that this doesn't happen to anybody, but if your relationship with your child sours and you wish to get the house back and you've done an outright transfer to them, you can. In the trust, you maintain a lot of power to change trustees, to change beneficiaries. So although you've given up a certain amount of perceived control where your house is concerned, you haven't given it all up. Another question. Is there an exemption for the homestead if an adult child caregiver lives there? Yes, great answer. So great question. So if you have to go into a nursing home and you have an adult child living in the home who has been providing caregiving services to you, you can transfer the home to that adult child caregiver, and that is an exempt transfer. You can also leave the house and it'll be exempt, but then when you pass away, you'll have the estate recovery issue. So if you go into a nursing home and you have the ability to transfer the house to an adult child caregiver who's been living in the home for 2 years immediately prior to institutionalization, then yes, that's another exempt transfer. There's also an exempt transfer to a disabled child or an appropriate trust for that disabled child. Husband is already on community Medicaid because of the virus. He no longer is able to go to day program. Now he is nearing the need to go on long-term memory care facility. How do you find out if you're eligible for chronic Medicaid? So certainly you can call me and I'll go through everything with you, but I'll tell you very quickly that if he's already eligible for community Medicaid and there's a spouse, which there is because you're saying my husband, and you haven't transferred any assets to anybody in the past 5 years, then under the spousal refusal laws of New York, your husband is eligible for Medicaid. The only thing that I would have to figure out is what, if any, the income contribution would need to be. And I'm happy to do that on a phone call with you. So if you want me to go over those numbers with you, you can just call the office and we can help you with that. Okay. All right. Okay. So the transfer to the adult child caregiver raises an interesting issue also. And that is, what if the plan was that everything was going to go to the 3 kids equally, but you've got the adult child caregiver? Does it make sense to transfer the home to the adult child caregiver? Again, it's certainly the route that I would take, given the need for emergency planning. However, it highlights again the necessity for early planning so that we can make sure that the house goes where it's supposed to go when the time comes. Same thing with special needs beneficiaries. We certainly have the ability to transfer assets to children with special needs. However, oftentimes that type of planning takes a little bit more time and consideration, because we want to make sure that if we're transferring assets to beneficiaries who have special needs, that we don't undertake any transfers that are going to make a child ineligible for benefits that they may be receiving. So we want to be careful with all of those types of transfers. Finally, if we just go back to the beginning, I think the most important point here is that while there are some ways to protect the homestead, even in the 11th hour, even when it's time for Medicaid and a nursing home, it's important to do the planning in advance if you can, so that we can make sure that we don't get stuck in any of these snags with intent to return home and possibly the loss of the intent to return home exemption. We want to make sure that although we use these provisions when we need them, the best planning technique obviously is getting the planning done 5 years prior to needing any care. What would make a child ineligible? So I have a question here and it says, what would make a child ineligible? I think what you're referring to is I said that we don't want to, so let's say that you have a child who has special needs and they themselves are receiving government-based benefits, but you want to do planning and you've got an exempt transfer to a disabled child. But if that child then receives money into their own name, they become ineligible for the benefits that they're receiving. So maybe they're receiving SSI and a transfer into their name would make them ineligible for the benefits that they're receiving. So that's where we often deal with supplemental needs trust, special needs trust, and transfers to trusts of those types. So we just want to be careful before transferring any assets from the Medicaid applicant to the disabled child that we take care to make sure that the disabled child doesn't lose their benefit. Okay. So I think, Liz, I think that's it. We will have another set of webinars next week. Thank you, everybody, again, for joining in, and I wish everybody a peaceful week.